The U.S. Constitution lays out broadly what the government can and can't do when it comes to your property. The Fourth and Fifth Amendments providing protections against the government taking your land. But inside of local governments, such as Martin County, there are several more layers of rules and regulations governing what you can and can't do with your property. Nicki Vonno, the director of Martin County's Growth Management Department, explains more.
When a person wants to develop their piece of property, they may do so in accordance with the rules and regulations that exist in that local community. That was an attempt to make it clear.
Nicki Vonno has been Martin County's Growth Management Director for 20 years. She says that just because there may be public opposition to a project, that doesn't mean the landowner's application will be denied.
If they are able to meet the rules and regulations of that community, then their application for the development should be approved.
She says commissioners are governed by local, state, and federal regulations that protect property owners.
Sometimes people have the idea that local elected officials can just do anything they want. Well, no, if they're good elected officials, they're going to want to make sure that their decisions are consistent with the rules and regulations that the county has to operate under.
The rules under which Martin County regulates land use is the Comprehensive Plan. That was first adopted in 1982.
We have a very strong comprehensive plan. We have a very detailed comprehensive plan.
The rules for developing land in Martin County and many other places can get very confusing. For example, there are many parcels of land with outdated Category C zoning designations, as they are called. Each time a developer wants to build on an old Category C zoning designation, they have to request the property to be rezoned to a current designation.
So a comprehensive plan amendment is legislative. It applies broadly to properties throughout the county. However, if it's a development application or a rezoning, it's considered what's called quasi-judicial. That means that the county commission is actually acting more like a judge.
And as a judge, the board is going to review the evidence that has been presented to them by the applicant and by staff to determine compliance.
When the board hears that application, they listen to public comment, but they have to rule as if they were a judge. They will have to either approve the application, approve it with conditions, or they could deny it, but only if they had competent, substantial evidence that it did not comply with the rules and regulations.
Nicki says that commissioners cannot deny site plan applications based on feeling, emotion, or public sentiment. And if an application is denied without just cause based on the evidence provided, the county could open itself up to a lawsuit.
We sometimes have people come to us and say, well, why are you allowing people to build so many of X? X could be gas stations, could be assisted living facilities, could be whatever they have a concern about. We don't dictate what a property owner can do with their property at that level of detail. If their land use and their zoning allows a gas station or allows an assisted living facility, it is up to the applicant to choose what is financially viable for them to decide how they're going to use their property.
For more information about land use in the county, go to Martin County's website at martin.fl.us and search Growth Management. For Martin County Television, I'm Bob Hoganson.